It was day 2 of hearing on whether there is a fundamental right to privacy or not. On day 2, the petitioners continued their arguments. While yesterday the main focus of the hearing was on whether there is a right to privacy or not, today the discussions went into a little bit of more of a detail as to if it is held that there is a fundamental right to privacy, what will be the contours of such a right. The petitioners told the court that there should not be an attempt to define or put limits on the definition of privacy, and it should be dealt on a case-to-case basis. The bench also asked certain questions from the petitioners, like for example, how will you define and distinguish between what is a legitimate curb on privacy and what defines an illegitimate curb on privacy. Senior advocate Sajjan Puvaya also made certain other arguments trying to address the issue of privacy in the modern times with respect to the technological advancement that have taken place. Mr. Puvaya told the court that invasion and the protection against invasion of privacy has legislative recognition in some cases, like example the RTI Act. He also told the court that it is not a question of debate that there should be a right to privacy, and right to privacy is the right which ensures that we follow and we exercise all our other rights freely and without any fear. Now remember, this was a hearing which was originally planned to conclude in one day, but it has already pushed on and moved on to day 3 on Tuesday. On Tuesday, the central government, which is represented by Attorney General for India, Mr. K.K. Venugopal, will put forward its argument on the stand it has taken that there is no fundamental right to privacy. It remains to be seen as to what other arguments will the government put forward to substantiate the stand it has taken in the Supreme Court.